produced by faculty. Can Shami? This is the first time, right? So
Yes.
so this is really uh, I have received the course outline. I'm not sure whether you all received the course outline or not, the content outline of the course, but it's really we are still working to improvise the syllabus, the course outline, because this is the first time. But bear in mind, this is a practical course. It is not a yeah, it's a practical course. So normally in course like this, for example, advocacy or civil procedure and things like that, so you will have to do assignments, you have to prepare coursework, you have to prepare the course papers. Normally what I did is that I give a reported case in journals to all of you, and then from that case you will extract the facts of the case, and then from the facts you will draft your pleadings, and then you will draft you will prepare your documents for trial, and then we will conduct the trial lah. We will practice by conducting the trial. But I really not sure how to do this semester, because the teaching is online, so it's quite difficult to teach advocacy online, because to practice, for example, to cross-examine witness, we need to be presence physically to be able to demonstrate how do you cross-examine a witness, how do you address the judge, how do you address the parties and things like that. So we cannot do that online, but I try to be fair to you. I will try to teach the theory of advocacy, but at the same time we will try to conduct practice by assignments and also drafting. So according to the course outline,
Hello, sir.
hello
Sir punya line ke kita?
hello, can you hear me?
Yes.
Yes.
Yes,
Okay,
we can hear.
Yes, yes.
Hello.
yes, okay, but I cannot see you all. You all of you are what, like switch off the camera or what? Because I just can't see Shami. So I'm really
There
like,
are few of us turning on their camera.
okay, why Aiyo. Okay, it's okay lah. I also don't know how do I do this. Okay, by the way, as I was saying, the course outline actually divided the course into two time period. The first 7 weeks is supposed to be the theoretical part, which is my part. So in this theoretical part for 7 weeks, I will be your lecturer. I will teach you the theory of advocacy. And then after your mid semester break, the rest of the 7 weeks after the mid break will be conducted by four facilitator, including me. So you will be divided into four big groups assigned to each facilitator, and that facilitator will assign a case to you, and also you will conduct the hearing and trial, and also the practical side of it after the mid break. So for the first 7 weeks, you are with me alone, and then we will talk about theories. My instruction by the instruction by the faculty is that for these 7 weeks is only a 2 hours lecture per week and no tutorial. Okay, uh, that is what I understand lah. But so no tutorial, and there is only a 2 hours lecture per week. So I'll be doing my lecture at night, 2 hours at night. So my plan is to do it on Thursday. Today is Friday because I just received my appointment and the faculty said that I need to conduct the class this week. I need to start by this week. So I don't have any day except today, Friday. But next week, I will conduct the class on Thursday at 8 to 10 p.m. Okay. So other than my subject, do you all have any other subject at night or on Thursday? No, so okay,
No.
Not yet.
okay. So I guess we can do the class, my class at night on Thursday every week for 7 weeks. Okay, so that's it as introduction. So the topic for this week is about the advocacy in general, basic etiquettes, introducing and addressing parties, addressing the judge, and language of advocacy. Before that, what are other subjects that you learn this semester? Will I mean I'm not sure of the structure of the course that your course, but do you have civil procedure?
Yes.
Yes.
So so you will learn also civil procedure this semester, is it?
Yes.
Yes.
Then you have criminal procedure, I suppose.
Criminal procedure, then criminal trial advocacy.
I see. What about professional practice? Do you have professional practice? No.
Professional practice, we already learned it on the last semester.
I see. So
Yeah.
okay. In that case, because this civil trial advocacy normally would overlap with civil procedure. So in civil procedure, you will learn what, like just theory of civil procedure, but not the practical part, is it? I'm not sure yet.
Uh, we do also drafting.
Also
As
drafting.
for yeah, as for now, we have made drafting on injunction because that is the first lesson that we have learned on last week. That is about injunction. So the lecturer had asked us to do the drafting on injunction.
I see. Okay, Shami, can you do me a favor after this? Can you send to me, email to me the course outline for civil procedure?
Okay,
Do you
sure.
have? Yeah. Because I really don't want the subject to be overlapping with civil procedure because I'm really confused now. Because the in this course civil trial advocacy, you will also prepare the case for hearing, a case for trial, but I'm not sure whether I need to assign you for drafting works because in civil procedure you have been assigned for drafting works, right? So in civil procedure, also you will uh, draft documents for trial, or only the applications, interlocutory applications.
Uh, as for now, only the application.
But never mind. We need to look at the course outline because it's quite because here in our course outline, civil trial advocacy, week 12 to 14, you will have a hearing of application for summary judgment, disposal of case on facts, substituted service, reinstatement, striking out, stay of proceedings. So it seems to me that it overlaps with civil procedure because this is all the applications. So and we have a practical simulation which is trial. So I really not sure as yet how to do this, but for this first 7 weeks we just uh, learn the theory first lah. Okay. Uh, Maybe I start with the advocacy in general. So the advocacy technically, what is advocacy? Okay, advocacy. I mean, we keep saying advocacy, advocacy, but what really is advocacy? Advocacy simply is how to convince people. How you convince people. So kadang-kadang you know pergi sembang dengan kawan. Do we have international student here? No, right? Ada. Do we have international student here?
No,
No, we
sir.
don't have.
No, sir. No.
So all of us are local Malay.
Malay,
Yeah.
Malay.
So boleh cakap Melayu lah.
Boleh.
Okay. So like bila you sembang dengan kawan-kawan, you know you want to convince your friend about something kan. Contohnya nak convince your friend to sokong your team bola for example. Okay, Manchester lagi bagus pada Liverpool and things like that. So that is the advocacy skill whereby you convince people. How to convince people to agree with you. That is advocacy. Okay. And number two, you can say that advocacy is how to effectively argue. Okay, how to effectively argue. Kita argue dalam hidup kita ni all the time, kan? You all mesti argue all the time lah. Kadang-kadang pasal YDPA tak nak bagi darurat pun you argue sampai pagi, right? So you apply all your constitutional law punya knowledge and then you argue with your friends sampai pagi about whether YDPA can whether Yang di-Pertuan Agong can actually reject the advice by Prime Minister. So you argue. But here advocacy will teach you how to effectively argue. Maksudnya you not just argue but you effectively argue something so that again to convince people to agree with you. Okay. Number 3, advocacy can be said to be to mean how to tell a story. Basically, how to tell a story, because in court, you have to tell the okay, what is your client's story? Okay, what is the narrative of facts that you need to convey to the judge so that the judge will sympathize to your client? What is the story that you want to tell the court so that the court will agree with you that your client is suffering loss? What is the story that you want to tell the court that actually in the case of accident, for example, your client tak salah? Okay, your client walaupun langgar orang tapi dia tak salah sebab orang tu yang masuk jalan dia. So you actually effectively in advocacy, you are telling a story. So the advocacy is the art of telling a story which can be believed supaya orang percaya cerita you. Okay, but advocacy skill can, you know, some people who can master advocacy skill, who is really profess or master in advocacy skill, can even convince a person with a fake story, can convince a person with a lie. Nak tahu ayah Pin kan, kerajaan langit, naik ke atas kerajaan langit dan turun balik, you know, ayah Pin yang mengaku diri sebagai Tuhan. I mean everybody know ayah Pin. But ayah Pin also has 50 or 60 followers who believe with ayah Pin's story. So how could a story so unreasonable, a story that cannot be believed at all at first instance, there are some people who can believe it. So that is advocacy. So Ayah Pin also have advocacy skill to tell a story that can be believed. Sama juga macam scam Macau. You know, Macau scam, Datuk Adi Kana or whatever, yang Macau scam also, they tell a story. They have this good advocacy skill. They have a very they are very eloquent in their speech. They tell a story that can be believed by people, walaupun that story is a lie, walaupun that story is a scam. You know, by just calling you through phone dan convince you that, oh, you punya a bank account has been used by a criminal to transfer illegal money from drug dealing, for example. Then you tak pernah, I mean, account you pun tak adalah banyak sangat duit, but then you actually believe the story and then you transfer the money to the scammer's account. So how can that happen? Because the scammer has a good advocacy skill. So this is advocacy, to tell a story. And then in the context of legal, advocacy is how to structure, okay, how to structure facts and law to form a valid legal argument. And that is advocacy, okay? If each and every case you have facts. Tak tahu lah. Okay. Tak apalah. Saya lama ni. Okay. At least you have some. Alright. Thanks. Sorry. I was saying that how to structure facts and laws to form a valid legal argument. Okay, so now it's different. Tadi saya cerita pasal tell a story. Saya cerita pasal how to you effectively argue, how you convince your friend, how you convince your parents nak beli motor, for example. Kan, budak-budak lelaki nak beli motor, you kena convince your parent untuk bagi duit. Oh, saya akan gunakan motor ni untuk kebaikan. Padahal dia nak bawa girlfriend, for example, tapi dia nak convince kan parent dia, okay, ni ada beberapa kebaikan yang saya boleh gunakan bila saya dapat motor. Saya akan pergi masjid untuk mendengar ceramah. Saya akan, pergi memberi bantuan kepada anak yatim. That's how you convince friend. But on the serious and professional context yang kita nak cakap throughout the semester is advocacy, in the sense that how you structure your facts and law to form a valid legal argument. Every case ada factsnya. Every case ada principle of law that you need to apply. Okay? So that facts and law must be structured accordingly when you submit to court to form a valid legal argument that the court can believe you. That is advocacy. That is advocacy. So kalau macam dalam trial, when you ask a witness, you use that advocacy to structure the facts. So that question to witness, the narration of facts, the question or your question to your witness will narrate the correct facts to convince the court. And then when you submit after the conclusion of trial, you will have to apply your law to the facts, and then you form a valid legal argument. That is advocacy. Okay, so advocacy is a big thing. It's some big words yang actually involve many perspectives. But in simply put, or in short, advocacy is how you convince people, how you form legal argument. That's it. Okay. So that is advocacy in general. Faham ke? Faham kan? Alright.
Faham tuan.
Any question? Ada soalan? Belum ada lagi. Kalau ada soalan,
Not yet.
tanya sebab not yet. Because it's really hard and difficult to just talking alone. So, apa? Somebody saying something? Okay, tak apa. Right, that is the meaning of advocacy, since this is civil trial advocacy kan. Okay, I just for this class I just want you to imagine being in court. Semua pernah pergi court? Ada tak yang pernah pergi court? Pergi actual court, pernah kan? Ada yang pernah, ada yang tak pernah.
Pernah.
Okay, siapa pernah? Okay, siapa yang pernah pergi court, you will know uh, the you know the situation in court. Okay, so just I want you to imagine, because now I'm telling you about the basic etiquettes in court. Etika yang perlu ada di court. Okay, first of all, decorum. Decorum, decorum, decorum. Decorum is ethics lah, cara you menghormati mahkamah, etika dalam mahkamah. So decorum will start dengan macam mana kita nak address mahkamah, macam mana kita nak panggil kawan peguam-peguam yang lain, how do we address the opponent, how we call the witness, how we call the judge. Okay, for example, mahkamah Malaysia ni menggunakan bahasa Melayu, tapi some of the court will use English, especially when you go to court of appeal, especially when you go to the federal court, and especially when you go to the high court before the non-Malay judge. Bukan racist apa, tapi non-Malay judge prefers to converse in English. Okay, some of the Malay judges also prefer to converse in English. So even if in high court, you have to be able to speak English very well. Okay, otherwise tak salah pun. I mean, kalau you nak cakap Melayu, that by all means lah, sebab bahasa mahkamah adalah bahasa Melayu. According to Akta Bahasa Kebangsaan, the language, court language is bahasa Melayu. But we also need to be be able to converse in English. Okay, so kena tahu dua-dua. So when you start your case, you akan duduk, the opponent is on the other side, you akan bangun to, if you are plaintiff, you will introduce first yourself. How to introduce yourself? Of course, you tell the court your name, and then who are you representing. Okay, saya bagi contoh, bangun dengan izin. Okay, sebut dulu dengan izin mahkamah, dengan izin yang arif, dengan izin mahkamah, dengan izin magistrate ke apa ke. Sebut dengan izin, nama saya Yusfarizal bin Yusof. Okay, saya mewakili plaintiff. Okay, that is the first thing you need to start. Ataupun in English, may it please your lordship, kalau lelaki, your lordship, may it please your lordship, ataupun may it please my lord. Okay, bahasa Inggeris ni memang macam tu. Kalau Lord dalam Bible tu jadi Tuhan. Tapi so in court punya language, yang arif is Lord. Sebab tu kalau you belajar reported case, English case kan, House of Lords. Pernah dengar? Okay, case House of Lords. Maksudnya apa? Itu macam federal court kita lah. Because it's House of Lords. Satu kumpulan Lord, judge. So we call it House of Lords. So dekat Malaysia, kita refer kepada judge mahkamah tinggi, kita refer sebagai my lord. Ataupun kalau kita in negative form, you call it your lordship. Okay, your lordship. May it please your lordship. May it please, kalau perempuan, may it please your ladyship. Ataupun may it please my lady. Kalau perempuan, my lady. Lelaki, my lord. Okay, in English. Dalam bahasa Melayu, yang arif lah, dengan izin yang arif. Sedang bahasa Melayu lagi lah. But better you start in Malay first. Okay, dengan izin yang arif, nama saya Yusfarizal bin Yusof. Saya mewakili plaintiff. Ataupun saya mewakili pihak plaintiff. Settle. Kalau you ada, you bring along your junior, your LA for example, you are partner, you boss, you bring along your LA. Okay, LA ni legal assistance, which is lawyer lah. lawyer tapi yang you gajikan dia. Okay, you bring along your LA. For example, my LA nama Adam. So you need to introduce dengan cakap macam ni. Dengan izin Yang Arif, nama saya Yusuf Rizal Yusof, mewakili pihak plaintiff, dan bersama-sama saya Encik Adam. Okay, dan bersama-sama saya Encik Adam. In English you say, my name is Yusuf Rizal bin Yusof. I'm acting for the plaintiff. And with me is Encik Adam. Okay, so settle. And then you introduce yourself. Second, introduce your opponent. Kalau you plaintiff, this is rule of etiquette. This is decorum. Jangan sekali-kali you pergi court tanpa you tahu nama opponent. So sebelum you start a case, you jumpa opponent, you minta nama penuh dia datang dengan siapa. Okay, tulis in a piece of paper and then pegang. And then you introduce. My name is Yusuf Rizal, acting for plaintiff. With me is Encik Adam. And my learned friend. When you refer to your opponent, when you refer to other lawyers, you must say my learned friend ataupun rakan bijaksana saya. Tak boleh dia. Macam tu je. Nama saya Yusuf Rizal. Dia ni Syami. Tak boleh macam tu. Okay. My name is Yusuf Rizal. Lawyer defendant ni nama dia Azhar. Tak boleh macam tu. You must say, nama saya Yusuf Rizal dan rakan bijaksana saya adalah Encik Syami. For example. Okay, itu quorum. Itu decorum. Itu ethics. Rakan bijaksana saya. Kalau dekat mahkamah syariah selalu kita panggil rakan apa dia orang pakai? Rakan terpelajar saya. Tak kisahlah terpelajar ke bijaksana ke. Sebab apa kita cakap dia bijaksana dan terpelajar? Walaupun kita tahu dia tak tahu apa pun. Belajar tinggi-tinggi tapi argument teruk pun. Tapi we still respect our opponent sebab dia pun belajar law juga 4 tahun, 5 tahun. Dia pun ada degree LLB juga. Dia pun ada degree law juga. So kita acknowledge the knowledge of the law by saying rakan bijaksana saya. Okay? Tak kira lah benci macam mana pun you dengan your opponent. Rakan bijaksana saya. Okay? Ataupun my learned friend. Alright?
Sir,
So you... Yes.
saya nak tanya, kalau dalam court tu ada 3 judge, dia akan jadi yang Arif, lepas tu ada yang Ahmad Arif ke atau sekali je?
Okay. Good question. Ini dengar betul-betul. Actually, saya akan terang benda tu. Tapi first of all, you all dah belajar hierarchy of court ya? Dah belajar kan? Hierarchy of court dah belajar belum? Okay, tak apa. Tak belajar, saya akan explain. First sekali adalah magistrate court. Kan? Yang paling rendah sekali adalah magistrate court. Magistrate court, kita panggil dia Tuan Magistrate. Okay? Tuan Magistrate. So, bila kita cakap dengan izin Tuan Magistrate. Nama saya Yusuf Rizal bin Yusof. Okay. Court nombor 2 adalah Mahkamah Session. Session Court kan? Okay. Mahkamah Session Court yang lebih tinggi daripada Magistrate Court. Mahkamah Session kita panggil apa? Tuan Hakim. Tuan Hakim. Dengan izin Tuan Hakim Yusuf Rizal bin Yusof. Okay, bila sampai ke Mahkamah Tinggi, baru yang saya cakap tadi. Okay, Mahkamah Tinggi kita panggil Yang Arif. Yang Arif, Hakim Mahkamah Tinggi tak payah sebut lah. Yang Arif saja. Dengan izin Yang Arif, saya Yusuf Rizal bin Yusof. Ataupun dalam Englishnya, my lord. May it please, may it please, my lord. Dengan izin Yang Arif. Okay, soalan Wan Suhaili tadi adalah kalau ada 3 judge. 3 judge tu dekat mana? Atas daripada Mahkamah Tinggi, we have the Court of Appeal. So the Court of Appeal will have 3 judges. Court of Appeal will have 3 judges. So kat sini kena hati-hati. Okay. Kalau the Court of Appeal, okay, among the Court of Appeal judges, dia akan ada seorang ketua. Nama dia Jawatan dia adalah the President of the Court of Appeal. Kita panggil PCA, the President of the Court of Appeal. Okay. Jangan tanya saya sebab apa Presiden. Memang dia bukan persatuan. Tapi dia memang naturally orang panggil President. So the President of the Court of Appeal, PCA. Okay. Kalau the quorum, 3 orang judge tu, yang duduk tengah-tengah tu, you tahu adalah President Court of Appeal. President Court of Appeal ni seorang je ya. Kalau dia adalah President Court of Appeal, you kena address dia Yang Amat Arif. Yang Amat Arif. Dalam sistem kehakiman ada 3 orang saja yang kita panggil Yang Amat Arif. 3 orang saja yang kita panggil Yang Amat Arif. Pertamanya adalah President of the Court of Appeal yang saya sebut tadi. Keduanya adalah Chief Judge of Malaya, Hakim Besar Malaya. Dalam kita panggil, lawyer panggil CJM, Chief Judge Malaya. Yang terakhir adalah siapa? Agak-agak siapa? 3 orang, President Court of Appeal, Chief Judge Malaya, satu lagi? Agak-agak korang lah.
Mahkamah Syariah. Tak.
Oh, ini civil court ni apa melompat ke masyarakat pula?
Sabar dan tahu.
Mahkamah Sarawak. Sorry? Again, tak dengar. Siapa? Seorang lagi.
Chief Justice.
Chief Justice tu apa? Siapa Chief Justice tu? Ada ke Chief Justice?
Ketua Hakim Negara.
Ketua Hakim Negara. Oh dia. Ketua Hakim Negara. Okey. So yang paling tingginya adalah Ketua Hakim Negara ataupun dalam bahasa Inggerisnya Chief Justice. Betul lah tu, Chief Justice. CJ. Kita nak panggil CJ. Itulah Chief Justice-nya. Sekarang ni Yang Amat Arif Mulia Tengku Maimun. Kan? So Ketua Hakim Negara. So 3 orang ingat, 3 orang yang pakai Yang Amat Arif, President of the Court of Appeal, Chief Judge of Malaya, Hakim Besar Malaya, dan ketiganya adalah Ketua Hakim Negara. You all balik cari siapa sekarang ni President Court of Appeal, siapa sekarang ni Chief Judge of Malaya, siapa sekarang ni Ketua Hakim Negara, saya dah beritahu tadi. Next class saya akan tanya. Okay? Itu kena cari. Saya tak nak bagi tahu. Okay. So ketiga-tiga orang ni dipanggil Yang Amat Arif title dia. So kita pergi dekat Court of Appeal tadi, kalau ada 3 orang, salah seorangnya adalah President of the Court of Appeal, awak kena sebut Yang Amat Arif, Yang Arif. Dengan izin Yang Amat Arif, Yang Arif, saya Yusfariza bin Yusof. Sebab ada 3 orang kan? Dan seorang Yang Amat Arif, 2 orang lagi Yang Arif biasa saja. So Yang Amat Arif, Yang Arif. Kalau 3 orang tu tak ada President Court of Appeal, you just bangun cakap dengan izin Yang Arif. Dia jadi Yang Arif kuasa 2 lah. Tak payahlah dengan izin Yang Arif. Dah sama kan? Dengan izin Yang Arif, Yusfarizal bin Yusof bagi pihak perayu. Okey. Di Mahkamah Rayuan tak ada plaintiff defendant dah. Di Mahkamah Rayuan ada perayu dengan responden saja. So kalau if you are the appellant, so you are perayu lah dengan izin Yang Amat Arif, Yang Arif, Yusfarizal bin Yusof bagi pihak perayu. Ataupun may it please your, okay. Bila dalam bahasa Inggeris, dia tak ada beza antara Yang Arif dengan Yang Amat Arif. Dia semua my lord je. Okay, your lordship sama je. Dia tak ada Yang Amat Arif tu jadi your most lordship ke apa, tak ada. So just your lordship ataupun my lord. Cumanya kalau judge dekat mahkamah rayuan tu ada for example 2 orang perempuan dan seorang lelaki. Okay, for example 2 orang perempuan dan seorang lelaki. Yang lelaki tu duduk kat tengah. Tengah tu dia panggil chair lah. Okay, tengah chair, lelaki, 2 orang perempuan kiri kanan. So you panggil, you cakap, may it please my lord and my ladies. Okay, start dengan yang kat tengah tu my lord and my ladies, dan juga my lady lah. So may it please my lord and my ladies, my name is Yusfariza bin Yusuf, I'm acting for the appellant, and my learned friend Encik Adam for the respondent. Okay, so kalau yang kat tengah tu perempuan, duanya lelaki, so may it please my lady and my lords. Terbalik lah, sama lah kan. So dia tak ada beza antara yang Ahmad Arif ke siapa ke, sama je. So then after that you go to federal court. Daripada court of appeal atas lagi you go to federal court. Okay. Federal court ada 5 judges ataupun 7 judges ataupun 9 judges. Normally 5 judges. Okay. When you have 5 judges, sometimes the CJ will sit on the panel. Okay, Ketua Hakim Negara akan jadi chair kepada sidang tersebut. Okay, for example, recently case Bin Abdullah or something. If I'm not mistaken, the CJ is the chair. So kalau CJ chair, you kena address Yang Ahmad Arif dengan izin Yang Ahmad Arif, Yang Arif. Okay. Sebab CJ ada. Kalau CJ tak ada, you just call dengan izin Yang Arif. That is sufficient. Okay. Faham tak? Okay. Kalau in English, sama jugalah. May it please my lord. Kita punya CJ perempuan kan. May it please my lady and my lord. Kalau yang lain perempuan. Ataupun kalau ramai perempuan, may it please my ladies and my lords. Okay, so that is how you address judge daripada magistrate court up to the federal court. Okay, so that is answering Wan Suhaili's question. Any other question with regards to addressing the judge? Okay. Right. And then you address your opponent. Remember I said just now, you have to take down the name of your opponent. And then you sebut, my learned friend Adam Luqman for the defendant. And with him, kalau dia dah ada datang bawa LA dia, with him, Encik Muhammad Syami, for example. Ataupun dalam bahasa Melayu, rakan bijaksana saya Encik Adam Luqman bagi pihak defendant dan bersama-sama beliau Encik Syami. Okay, bersama-sama beliau Encik Syami. Faham? So, you address your opponent. Okay. So, that is the ethics in court. Okay. And then about the ethics and courtesy in court also, kalau dekat court you see in court dia ada rows of bar table. Ada banyak meja. Okay, ada. So if you are junior, kan, macam you all baru practice, masuk baru first year ataupun baru chambering, you start your chambering and then you long call and then you masuk first year, baru praktis, baru jadi LA, you pergi court. Tiba-tiba you nampak court penuh, tiba-tiba you nampak court kosong. So, you pun pergi depan duduk dekat first row. Okay. As a rule of courtesy, as a rule of etiquette, junior cannot sit in the first row. Jangan you pergi terus terjah duduk kat first row. Ini bukan macam soft solat. Soft solat, siapa sampai dulu duduk depan, tak kira siapa. Because kita nak menghadap Allah. Tapi ini dekat court ni dia ada rules and ethicsnya. Sebab apa? It's not without reason. The reason is nanti akan ada senior lawyer yang jalan pun tak apa nak larat, suara pun tak apa nak jelas. So dia kenalah duduk depan supaya when he speaks, the judge can hear. You orang muda, you boleh duduk belakang, your voice is strong and loud enough to be heard by the judge. Itu saja reasonnya. So you as junior, don't sit on the first row. Duduk belakang-belakang sikit. Bagi the more senior lawyer to sit in front. So that is the rule of etiquette. Kalau you tak observe, orang akan nampak you ni macam very rude and tak tahu ethics. Tiba-tiba you datang, you terus parking bag you apa semua dekat depan, so tak peduli orang lain. So senior datang lambat sikit, dia kena duduk belakang. That is unethical and not nice lah. Orang akan tengok ni siapa ajar dia orang ethics ni, siapa ajar dia orang advocacy ni, siapa ajar budak ni chambering kat mana ni sampai tak tahu rule of ethics. Okay, so that is as to the sitting in court. Okay, next is the dressing. You need to understand your attire. Okay, of course kita tahu lawyer hitam putih, okay, black and white, but ada dua jenis attire, right? First is you wear black trousers ataupun black skirt and white shirt ataupun white blouse, ataupun perempuan boleh pakai baju kurung hitam putih, and you wear a blazer, you wear a jacket. Kalau lelaki pakai jaket hitam and then you wear a necktie. Kalau perempuan pakai jaket sajalah, pakai jaket hitam. So that is the attire for lower court, which means the attire for magistrate court and session court, plus the attire for high court in chamber. Okay, itu adalah pakaian untuk mahkamah magistrate dan mahkamah session, dan juga mahkamah tinggi kalau you masuk dalam kamar hakim. Okay, if your application was called into the chamber, interpreter cakap okay, ini hearing injunction, for example lah, you buat injunction CP kan sekarang kan. So your hearing of your injunction application will be in chamber. So you masuk chamber, you pakai blazer, you pakai tie. Okay. Second attire adalah yang you pakai baju kelawar tu. Bukan baju kelawar, I mean the robe. Okay. Pernah tengok kan robe kan? Yang lawyer pakai robe. Macam bergebang tu kan. So that is robe. And jubah ni you pakai sama juga, white shirt, black trousers, tapi ada tambah bib. We call it bib. Bib ni dia ada macam dua apa nak cakap, dia ada macam saya tak bawa contoh pula. You pernah tengok tak? Alah, tengok dalam drama Melayu pun ada benda ni.
Kita pernah pakai
Okay.
sir.
Pernah pakai. Bagus lah. Okay. So you pernah pakai untuk apa? For what subject? Mock trial.
Subjek muting.
Oh, you ada buat muting. Bila?
Dah.
Buat dia cepat.
On third year, fourth year.
Oh. Jangan penat lah saya ajar macam tu. Tak apalah, saya ajar je lah. Mana tahu you tak ingat je. So, bib lah. You wear the bib. And then you wear the jacket. And then you pakai robe. Ini adalah untuk open court matter in high court. Saya kena stress benda ni sebab ramai orang yang silap. Ramai orang yang confused bila pergi court, dia pakai macam lain. Okay, open court in high court, you pakai robe dan bib. Nombor satu. Okay, apa maksud open court matter? What is the difference between open court matter and chamber matter? Okay, chamber matter tadi yang saya cakap injunction application di dalam kamar hakim. Kamar hakim tu dekat belakang court, ada bilik dia, you masuk dalam bilik, you argue dekat dalam tu. That is chamber matter. You pakai apa? Tie dengan jacket. Okay, tie dengan jacket. bila matter tu di open court, maksudnya di luar, yang ada public gallery, ada bar table, kat luar tu lah, yang dewan tu kan, the hall, the court hall tu, then you wear bib and rope. Because it is an open court matter. Open court matter ni apa? Apa benda yang open court matter? Trial lah. Kalau you buat bicara, you panggil saksi, dekat open court lah you panggil saksi. Kan? Kalau dalam chamber macam mana nak panggil saksi? So open court matter, you wear bib and rope. Untuk perempuan pun ada bib dia, bib bunga-bunga tu kan. And then you wear your rope. Okay. Tiba-tiba bila you dekat dekat open court, you argue. Judge cakap, okay, stand down, kita masuk in chamber. I want to ask something in chamber. You pun masuk chamber. Okay, bila masuk chamber kena pakai rope ke tak? Tak pakai. Buka rope, masuk saja in chamber. Tapi you pakai bib. You nak kena tukar tie ke?
Tak payah, tak perlu.
Tak payah. Sebab bib also can be acceptable kalau you tak pakai tie. So masuk chamber pakai blazer, pakai bib, masuk. Tak ada masalah. Okay. And bib and rope juga kena dipakai di Court of Appeal dan Federal Court. So bib dengan rope hanya pakai di Court Mahkamah Tinggi for open court matter, the Court of Appeal and Federal Court. Dan Court of Appeal dengan Federal Court, there is no chamber matter. Tak ada benda dalam chamber, semua open court. Okay. So that is with regards to your attire in court. Dan untuk Muslimat, ladies, jangan pakai striking colour. Of bawa handbag pink terang ke, pakai kasut merah ke, tak boleh. Dan guys, you cannot wear striking tie. Pakai elok dah blazer hitam tapi pakai tie warna oranye. Cannot. Mesti pakai tie yang warna gelap ataupun warna yang tidak menjolok mata. Okay, sama ada blue black.
Lipstick tu.
Kalau Razak warna striking rambut. Yang jambang-jambang warna orange.
Soalan yang bagus. You all minat lah ni Alan Razak ni. Okay. Setakat ni Siti Kasim dan Alan Razak lah rambut dia macam tu kan. So tak apa. Setakat ni because the Bar Council ruling, there is no restriction with regards to the colour of your hair. Okay, there is no restriction with regards to colour of your hair. So bila tak ada restriction, that's why lah you tengok setengah-setengah lawyer datang dengan rambut blonde. Okay, tapi kita universiti belajar agama semua kan. So tak payahlah nak blonde-blonde rambut. Okay, yang dia orang dah blonde tu nak buat macam mana? But then even if dia blonde pun dia kena kemas, and the judge can refuse to hear. The judge boleh halau dia keluar daripada court if the judge feel that it is not nampak tak proper, merebang ke, rambut afro ke sangat. So judge boleh tak nak dengar. The judge boleh halau. Okay. Dan perempuan pun, perempuan pakai tudung tak ada isu rambut lah. Melainkan kalau you nak join geng Siti Kasim, then you buat rambut blonde, then susah lah. Kan? Okay. Dalam masa yang sama, at the same time, for siapa-siapa yang fan Nilofa ya. Yang fan Nilofa dan pakai what do you call that? Purdah. Niqab. Okay. Saya bukan nak bincang pasal hukum niqab ataupun sama ada Nilofa tu macam mana kan. So baguslah pakai niqab. But in court you cannot wear niqab. Okay. So ada dua tempat you tak boleh pakai niqab. Kat mana? I mean except your home lah. You know, ini maksudnya public place lah. Dekat rumah memang lah. Ada dua tempat you tak boleh pakai niqab. Satu dekat court macam saya cakap tadi lah. You tak boleh pakai niqab, dia tak boleh. Sebab judge nanti you pergi sebenarnya you bukan lawyer, you berlakon ke apa semua, nanti banyak isu. Tapi the guideline also say that you cannot close your face lah. Nombor dua kat mana? Tak boleh pakai niqab.
University.
University tak boleh pakai niqab eh?
Tak mesti.
Tak boleh.
Oh tak boleh.
Tak boleh.
Dekat usia pun tak boleh.
Tak boleh. Haram.
Lelaki pun
Haram.
Exam.
Serban
seriously
tak
tak
boleh.
boleh.
Tak boleh sir. Takut
Di
imposter.
mana freedom tiba-tiba. Oh, I don't know that. Oh, okey lah, maksudnya ada banyak lah tempat tak boleh. Saya ingat boleh. The other thing saya just nak cakap, satu lagi tempat you tak boleh pakai niqab ialah bila you tawaf. You tahu kan?
Oh.
You pakailah niqab mana pun, daripada negara mana pun, Pakistan ke, mana ke, Sudan ke, Nilofa ke, bila you tawaf, you tak boleh pakai niqab. Betul tak ustaz-ustaz sekalian? Tak boleh kan? Sebab you tak boleh tutup muka semasa tawaf. Itu syarat-syarat tawaf. Bukan syarat tawaf, I mean syarat sahnya lah. You tak boleh tutup muka, lelaki tak boleh tutup kepala. So, tak ada pergi tawaf pakai serban pula. Ini ajaran sesat. Okay? So, itu saja saya nak cakap. Tapi sekarang dah ada 3 tempat lah. Satu dekat court, masa tawaf dan juga dekat universiti. So I seriously don't know that. Saya ingat boleh je. Okay. So for niqabis, betul tak tu? Niqabis, you kena fight for your right. Kan? Kalau setengah orang ada hak untuk berambut blonde, ada, hello?
Ya.
Oh, okay.
Yes,
Dia
sir.
tiba-tiba hilang. Kalau ni ada orang record kan, komplain saya ke apa kan. Tak apalah, dengar lah, komplain lah. You kalau ada, if there is a right to be to blonde your hair and appear ni, pakai benda-benda yang ni, kenapa orang yang nak berniqab tak boleh kan? So I don't know, maybe there's a reason for that. But then that's why lah, I mean, kita selalu argue in court about freedom, fundamental liberties, freedom. Ada setengah orang argue that, you know, sampai freedom of you nak
Sir.
apa tu?
Hello.
Hello, sir. Sir punya line
Yes, sir, hilang.
Hello.
Shoki mute, Shoki.
Dah boleh left ke?
Hello.
Oh, sir kata dia terkeluar.
Oh.
Tak apa ni. Tunggu.
Hello sir.
Hello.
Baru dengar.
Tiba-tiba saya terkeluar daripada this, I don't know. Ada orang sabotaj ke? Baru
No, sir.
oh, seriously. Tiba-tiba saya dah blank, screen saya dah keluar. So, adakah saya tak boleh bercakap dengan bebas? Ada orang monitor saya bila saya cakap something against university ke apa, dia orang buang saya, tak ada Kalau ada pun I don't care. Okay, so tak ada okay, tak ada, bagus. I mean just saying lah, tapi you cannot wear niqab in court lah, sebab some maybe untuk identification purpose. Okay, so that is with regards to your attire. And then apa lagi tadi? Your attire. Okay. Dekat court juga, you kena, you pergi court, you kena register your name with the registrar. You kena make sure that documents you file is ada dalam court's file. So you will have to liaise with the interpreter and the registrar of court. So be courteous also, not only to your opponent, not only to your judge, but also to the court officer, the registrar, the interpreter. So diorang pun adalah officer of court yang you kena buat baik dan beretika. So you approach them, cakap betul-betul, puan, selamat pagi puan, boleh saya daftar nama saya, kes saya sekian. Be courteous to them. Jangan macam, oh I want to sign attendance apa semua ni. Kat mana attendance? Okay. Sebab dia orang juga adalah officer of court, dan timbalan pendaftar dan penunung kanan pendaftar is actually a law graduate juga. So dia orang pun sooner or later will become a magistrate, sooner or later will become a session court judge, dan dia akan ingat you. Oh budak ni hari tu yang tak ada etik sangat. Okay, main terjah saja. Tak ada etik untuk bercakap dengan registrar dan juga interpreter. So be courteous to everybody. Okay. At the same time, rule of etiquette juga, kalau you were chambering, pelatih dalam kamar, okay, you cannot you mestilah diintroduce dan you cannot introduce yourself dekat high court. You mesti orang lain bawa you dan diintroduce your name as pelatih dalam kamar, and mohon izin daripada mahkamah untuk you duduk di bar table. Contohnya saya bawa chambering saya, okay, nama saya Yusuf Rizal bagi pihak plaintiff, dan bersama-sama saya adalah Wan, iaitu pelatih dalam kamar saya, dan saya memohon izin daripada mahkamah yang mulia ini untuk pelatih dalam kamar saya duduk di sebelah saya. Kena minta izin. Alright, so that is a rule of ethics juga. Okay, on top of that adalah professionalism. Okay, yang ni adalah penting kerana professionalism ialah basically apa? Basically baca file lah. If you go to court, having a hearing, have a case management, you kena prepare your file. Baca your file. Okay, jangan bila judge tanya, you tak tahu apa. You know nothing about your file. So, it's professionalism. Okay. And professionalism juga and ethics juga akan dictate bahawa kalau opponent you belum datang, if your opponent is still not there, you must wait for your opponent, dan don't address the judge without your opponent. Don't address the judge without your opponent. So kalau opponent datang lambat, court dah panggil your case, you bangun, you cakap, Yang Arif, rakan bijaksana saya, peguam defendant belum sampai. Saya mohon untuk tangguh sebentar kes ini. Okay, jangan terus cakap, oh ya Arif, saya hari ini adalah ditetapkan untuk pendengaran injunction dan saya ni. Lepas tu yang Arif akan tanya, where's your opponent? Belum sampai. Yang belum sampai, yang you nak argue buat apa? You nak argue seorang-seorang. Okay, so wait for your opponent. And then kalau dia lambat, you call dia, cakap lambat lagi ke apa semua. That is a courtesy to the fellow opponent. Kalau let's say dia tak datang langsung, okay, dia terlupa ke, you call pun tak dapat, you kena cakap apa? You kena aku janji kepada mahkamah untuk bagi tahu your opponent the outcome of the mention ataupun hearing. Cakap kat court, my lord, I undertake to inform my learned friend, the lawyers for the defendant, the outcome of today. Aku janji untuk memberitahu. That is courtesy. Walaupun dia tak datang, dia terlupa ke dia apa, you balik, you kena call dia, you kena bagi tahu ataupun you send letter. Okay, then you undertake to inform. Next related thing also adalah kita panggil mention on behalf. Okay, pernah dengar? MOB. Okay, mention on behalf. Mention on behalf means, contoh, saya plaintiff, Adam tadi defendant. Tapi for some reason on that day Adam tak boleh datang sebab dia kena pergi hospital. So Adam pun call saya dan cakap, Cik Yusfarizal boleh tak tolong mention on my behalf. Mention on my behalf adalah menyebut bagi pihak. Dalam bahasa Melayu, menyebut bagi pihak. Menyebut bagi pihak means you tolong appear bagi pihak dia. Okay. Tapi kalau hearing tak boleh lah. Macam mana you nak appear bagi pihak hearing? Tapi kalau mention boleh. Kalau mention you pergi dengan izin yang Arif, nama saya Yusfarizal, peguam cara plaintiff. Saya menyebut bagi pihak peguam cara defendant yang mana tidak dapat hadir kerana sakit. Okay, lepas tu yang Arif cakap, so you nak apa? Saya dan peguam cara defendant telah bersetuju untuk mendapatkan satu tarikh yang baru. Saya pohon tarikh baru daripada mahkamah. Okay, so that is mention on behalf. Ataupun, okay, itu satu, mention on behalf of your opponent. Keduanya, mention on behalf of other lawyers. Contohnya, awak ada kes dekat Kedah. Okay, you ada kes kat Kedah. You nak pergi COVID, tak boleh pergi. Zon merah, Kota Setar. Zon merah, tapi you ada kes esok. You ada kes hari Senin contoh. So, you tak boleh pergi. So, you pun call your friend in Kedah. Okay, call your friend in Kedah. Boleh tak you pergi court esok, tolong mention on behalf. Tolong sebut bagi pihak saya. So, your friend pun akan pergi. Okay. Dengan izin yang Arif, saya Yusfarizal bin Yusof menyebut bagi pihak peguam cara plaintiff. You are not plaintiff solicitor, but you mention on behalf of plaintiff solicitor yang ada dekat KL yang tak dapat datang. And then, saya menyebut bagi pihak peguam cara plaintiff dan ini rakan bijaksana saya adalah peguam cara defendant. Okay, so itu maksud menyebut bagi pihak. Lawyer mesti bekerjasama, cooperate with each other, help each other kalau ada kesulitan. So, you all 70-80 orang ni nanti you all practice, you have to help each other. Ada yang duduk Kedah, ada yang duduk Kelantan. Because of simple mention, you nak dapatkan date. Takkan you nak fly to Kelantan. Takkan you nak drive to Kedah. Call your friend, ask them to mention on your behalf. Okay, faham? So far ada soalan. Is there any question? Ada tak? Tak ada. Okay, we have another half an hour. Saya ambil sikit lagi. Saya tengok semua pun dah boring. Apa rasa mengarut ni kan. So, how do I share the slide ke apa ke? Share desktop eh?
Dekat button atas sebelah mikrofon tu ada share content
desktop
tu.
Kan? Share content.
Yes.
Share content eh?
Then saya klik mana yang saya nak share tu lah.
Okay. Okay, this is the for early preparation of trial. Okay, dia dah masuk serius sikit, tadi santai-santai je. So before you prepare a trial, saya nak ajar you all how to analyze the case. How to analyze the case. Bila you dapat case, how to analyze. And kita start any case with the dipanggil 5 level case analysis. 5 level case analysis. So ini very important. Mungkin you all dah belajar, mungkin you all dah tahu pun, but this is important untuk senang you brainstorm apa
Lagging.
Sir,
Saya tak dengar, sir.
ya, sekali lagi saya tertulis. So dia suddenly hilang je. You have ni, so tak apa.
okay.
5 level case analysis for you to analyze each and every case untuk you clearly understand the case. So I share the slide now. You all nampak tak? You all
Nampak.
Pak,
the 5 level case analysis. The 5 level case analysis tu nampak Okay.
Nampak sir, clear.
Okay, clear. Alright. So this is the 5 level case analysis model. So first kali bila we dapat case, you need to identify what is the legal source of the case. Okay, legal source maksudnya having received full and comprehensive instruction, you research the law thoroughly and identify the source of client's right. Okay, basically case ni case apa? Whether it's a tort case, whether it's a contract case, whether it's a Companies Act punya issue, whether it's issue of enactment pentadbiran agama Islam negeri or whatever issues. So this is the source of law. Okay, source of law maksudnya area besarnya apa? Bila datang kes kat you, okay, kes ni kes contract because there is an agreement, because ada contractual right between parties, so it is a contract. The legal source is contract. Tapi kalau datang kat you, okay, anak saya pergi hospital and then doktor buat operation, lepas tu tiba-tiba anak saya jadi lagi teruk dan saya rasa doktor dah negligence. So for example, negligence would be, the legal source would be tort. Okay, will be under tort. You all dah belajar kan tort and contract? Belajar tak? Dah belajar. So legal source is either tort or contract or any issues with regards to particular statute. For example, Companies Act. Kalau isu contohnya shareholder bergaduh dengan shareholder yang lain, director bergaduh dengan director, is the Companies Act punya issue. Ataupun land law matter. Okay, the legal source is land law when you have a case of bergaduh berebut tanah pusaka for example. So it's a quarrel between family members to determine who has the right over the land. So that is a land law matter. The legal source is land law. So after you determine, the first level is legal source. After you determine the legal source, then you determine what is the cause of action. Okay, what is the cause of action? In respect of each of cause of action, define it with precision. There may be more than one cause of action. Example, breach of contract, breach of section of Companies Act, tort of libel defamation, and so on so forth. Okay, so for example, you dapat case, you cakap, okay, confirm. The first level, this is a contract case. Okay, tapi contract case, the cause of action can be various, can be many. Okay, first, adakah this is the breach of contractual terms, for example. Ada contract, ada terms of the agreement, but then one party failed to perform their obligation. So it is a case of breach of contract. So the cause of action is breach of contract. Contract itself is not cause of action. Contract is the legal source. Okay, but the cause of action is breach of contract. Contract, ada juga case dia tak nak continue with the agreement. For example, jual rumah, pembeli dah bayar 10% deposit tapi purchaser tak nak proceed with the contract. So defendant, the buyer want to compel the plaintiff to proceed with the sale and purchase agreement, for example. So in that kind of case, the cause of action is specific performance, because plaintiff want to defendant to specifically perform and continue with the contract. So the legal source is contract, the cause of action is specific performance. Okay, and another example in tort case, the legal source is tort, tapi the cause of action can be, for example, defamation. Tort of defamation. You belajar kan tort of defamation? So case datang kat you, ada orang post dekat Facebook kenyataan fitnah, and then you want to sue him sebab memfitnah. So you letak kat situ, the cause of action is defamation, libel defamation or slander defamation. Okay, the legal source is tort, the cause of action is defamation. Ataupun case of medical negligence, the tort is medical negligence, the legal source is tort, the cause of action is medical negligence. Apa lagi tort yang ada? Defamation, negligence, nuisance, trespass. Yes. So all this is the cause of action under level 2 of case analysis model. And then what is, okay, dalam level ni juga you can determine apa jurisdiction. Okay, untuk cause of action ni jurisdiction apa? Court ke, tribunal ke, dan siapa sepatutnya jadi plaintiff, siapa sepatutnya jadi defendant. So this is level 2 cause of action. Okay, next level, when you identify cause of action, you can identify pula what are the elements of cause of action. Element tahu kan? Okay, for example tadi, legal source adalah tort, the cause of action is defamation, and then apakah element defamation? Okay, you belajar defamation. Element defamation apa? First, it must apa?
There
Siapa tahu?
must be a definition.
Must be published.
Yeah, that is one of them. First adalah it must refers to plaintiff, kan? And then it contains a defamatory remark. The third element is must be publicized dan published. Dan fourthly, the plaintiff
reputation is tarnished.
Yes, suffered loss and damages in terms of loss of reputation. So that is an element of defamation. So the third level is you identify what are the elements. For example, in medical negligence, what are the elements of medical negligence? Apakah elemen of medical negligence, for example? Siapa tahu? Medical negligence. Come on, what are the elements? Huh? Apa dia? Sorry. Damage. Siapa yang damage? Siapa yang damage?
Duty of care.
Professional duty
Yes.
of care.
Yes. First kali, element of negligence. Mana pula you all? Adalah duty of care. Right. You all nampak the slide ke? Nampak yang Microsoft Team punya ni? Nampak slide kan?
Nampak slide.
Okay. Alright. So, for example, first is duty of care. Second element is breach of duty of care. Breach of that duty of care. And then thirdly is losses and damages. So, itu element of medical negligence. So, apa lagi? For example, kalau breach of contract, the legal source is contract. The cause of action is breach of contract. What are the elements of breach of contract? For example, first you kena ada contract. Keduanya, terms of the contract, and then the failure to fulfill the obligation under the terms of the contract. So that is the elements for breach of contract. So you identify the element, and then kalau ada relevant section, for example, of the act or principle of general law applicable, so you apply and identify each of the matters which require separate proof. So that is level 3. Level 1 is legal source. Second level is cause of action. Third level is element of the cause of action. So what are the fourth element, fourth level? So the fourth level would be the facts required to prove each element. Okay, tadi kita ada elemen, contoh kita ada 3 elemen, tapi apakah fakta-fakta yang boleh menyokong setiap elemen? So consider all facts and allocate them under the appropriate ingredient headings. When no apparent fact is available to support an ingredient or where a fact is not a strong one, investigate what other evidentiary facts may be relied upon to support the case. For example, medical negligence. Okay, medical negligence is the cause of action. The first element is duty of care. So how do you, apakah facts yang boleh establish duty of care? Contoh, facts yang boleh establish duty of care adalah bahawa pesakit telah pergi ke hospital dan telah berjumpa dengan Dr. Ashraf, for example. Dan Dr. Ashraf telah bersetuju untuk menjalankan pembedahan terhadap pesakit. Okay, to do the operation. So, ini menunjukkan bahawa there is a duty of care antara pesakit dan Dr. Ashraf. Okay, so factsnya apa? Factnya pesakit pergi jumpa Dr. Ashraf buat operation. So, that is duty of care. Sebab Dr. Ashraf is a professional doctor. So, itu fakta untuk menyokong the first element. Second element, breach of duty of care. Apakah fakta yang boleh support the breach of duty of care? Contohnya kita cakap Dr. Ashraf telah menjalankan pembedahan dekat perut pesakit tetapi tertinggal gunting di dalam perut, for example. Okay. Tertinggal gunting di dalam perut yang menyebabkan pendarahan. Sepatutnya tak boleh tinggal gunting dalam perut. So, the fact that he left the scissor in the stomach is the facts which can prove the element of breach of duty of care. Okay, and then the third element is loss and damage, losses and damages. So apakah facts yang boleh support that losses and damage? Selepas daripada pembedahan, perut plaintiff berdarah, mengalami pendarahan dengan teruk sehingga kan beliau maybe perut beliau tidak dapat berfungsi dengan seperti sedia kala dan dia terpaksa duduk di ward selama 3 bulan dan dia pun kena makan ikut tube saja, for example. Ataupun kalau dalam kes perempuan, contohnya ada real case medical negligence yang mana buat operation untuk bersalin, tertinggal gunting dalam perut dan pendarahan apa semua, so dia punya uterus ataupun rahim rosak dan tak boleh digunakan lagi, tak boleh melahirkan anak lagi. So that is the facts that support the losses and damage or injury suffered by the plaintiff. So nampak tak? So the element, you mesti ada facts yang support that element. So facts tu banyak, ceritanya panjang, tapi you kena suits into the each element. Okay. So bila you ada facts, you dah ada facts tadi, the last level, this is level 4. So kalau you buat chart nanti you akan ada level. So the last level would be what are the evidence required to prove each fact. Ini kena clear betul. Sebab you all your tendency you akan confuse what is evidence, what is facts. Okay, saya ambil contoh tadi balik, medical negligence ya. First element, okay, legal source adalah tort. First level adalah tort. Second level adalah medical negligence, cause of action kan. Third level adalah element of the cause of action, which is tadi kita cakap duty of care, breach of duty of care dan losses. Fourth level adalah facts to prove the element. So facts tadi saya ada cerita panjang tadi. Dia jumpa doktor buat operation bla bla bla. And then the last level adalah evidence. For example, facts tadi Ashraf pula. Facts tadi adalah pesakit pergi ke hospital pantai jumpa Dr. Ashraf. That is a facts, right? But what are the evidence to prove that facts? Apa evidence-nya? Bagi contoh. What are the evidence to prove that facts?
Receipt.
Surat appointment.
Yes, very good. Okay. Admission form. Okay, you pergi hospital, you sign admission form. Admission form tu ada tulis nama pesakit apa semua dan dia tulis kat situ assigned to Dr. Ashraf, for example. So that admission form is the evidence to establish the element of duty of care by Dr. Ashraf. And then okay, aku ada receipt pembayaran. Yes, somebody said receipt pembayaran. Somebody said what? Surat or whatever. So that is evidence. Evidence adalah bukti-bukti untuk menyokong fakta. Okay. And then breach of duty of care. Dia buat operation tinggal gunting tadi dalam perut, for example. So what are the evidence? Maybe a medical report. Okay. Laporan perubatan yang menunjukkan ada gunting tertinggal dalam perut. Saya ambil contoh ekstrim lah. Gunting tertinggal dalam perut. Ataupun the x-ray report. Bila kita pergi x-ray dekat hospital lain, selepas tu nampak x-ray tu nampak gambar gunting. Right? Nampak gambar gunting. So, that is the evidence to support the breach of duty of care. And then losses tadi saya cakap, dia contohnya dalam kes perempuan tadi, rahim dia dah tak boleh pakai, uterus dia dah rosak apa semua. What are the evidence? The evidence mungkin juga medical report or expert report dan sebagainya. Dan evidence bukan saja by way of documentary evidence, it can be by way of oral evidence. What is oral evidence? The testimony of witness. For example, you nak provekan the facts bahawa memang you tak ada nak provekan bahawa the patient tadi jumpa Dr. Ashraf, tapi you tak ada admission record, you tak ada form of admission, you tak ada receipt, you tak ada apa, semua dah hilang. So, the only evidence yang you ada adalah testimony of the patient's husband. Sebab patient husband datang masa nak admit tu dia ada sekali dan dia testify dalam court, ya saya bawa isteri saya pergi hospital dan saya bawa pergi jumpa doktor tu pakai name tag nama Dr. Ashraf. So, that is evidence. Testimony by the witness is evidence. It also can be used as evidence to prove that facts. So it can be a documentary evidence, it can be a testimony of witness or whatever kind of evidence yang you all belajar dalam evidence law. Okay, so when you have this in your mind, ada level 1, level 2, level 3, level 4, level 5, apa saja kes yang datang kat you boleh analyse dengan cepat. You sampai dapat fact, dapat dokumen banyak, you terus generate, okay, legal source dia macam ni, cause of action ni, elemen dia macam ni, facts dia macam ni, evidence. So senang you interview your client, you boleh tanya terus. Sebab you dah tahu elemen in your head. Yang you tanya sekarang ni facts. You tanya terus, okay, sebenarnya masa admission tu macam mana prosesnya, you tanya. And then apa kesan, you tahu dah, you nak suit kat mana. And then what are the evidence? Ada tak tuan ada simpan lagi receipt apa semua? Faham tak? So, you dah ada framework dalam kepala you this 5 level case analysis, you kena ingat apa yang Sir cakap ni, Sir Yusfariza cakap, sampai the whole life, you're practicing life, ingat 5 level case analysis. So you akan okay, InsyaAllah. So tengok kat sini saya buat dalam dalam apa nama, the diagram. So it's legal source, cause of action, element can be more than one, and then facts pecah lagi, and then evidence. Okay. Okay, saya rasa cukup untuk setakat ni. Faham kan? Okay, ada soalan? Banyak lagi. Lepas ni kita akan belajar theory of the case. Macam mana you nak create theory. Okay, setiap case kena ada ceritanya. The theory of the case is actually you tanya, apa cerita sebenar case ni, ceritanya macam mana. Okay, you have the analysis. Tapi ada benda-benda yang pelik lah, kenapa tak ada yang ni, kenapa tak ada medical report, kenapa tak ada ni. So you nak create a theory. Nanti saya ajar how to create a theory, and then kita akan next week kita akan tengok macam mana nak prepare, what is the untuk strategi, macam mana you nak guna interlocutory application as strategy, and then macam mana you nak interview the client, and then macam mana you nak manage the case and organize the document apa semua, insya-Allah. Itu dalam tajuk pre-trial preparation. So hari ni introduction saja dan basic analysis of case. Okay? Kalau ada soalan? Saya duk nampak muka orang yang sama je. Yang lain ni ada 70 orang ni. Janganlah macam WhatsApp group alumni sekolah awak yang exchange message 3 orang je, yang lain semua silent reader. Padahal ada 500 orang dalam group. So I need you to respond to me so that I know whether you understand or not, whether Yus ni boring tak ingat ke, ataupun you know. Sebab ramai sangat you all, sampai 90 orang lebih. So normally satu kelas 20-30 orang boleh lah, saya pun boleh ingat nama ni, saya pun tak tahu. Saya I will just mention Syami sebab dia yang liaise dengan saya, sebab saya tak kenal orang lain. Unless you bersuara dan I can see your name. So whatever it is there any question? Tak ada. Tak ada. Okay. At least you respond by saying tak ada. That's good enough. Okay. Yes.
Tanya, kalau opening speech tu yang tadi yang saya ajar tadi tu ke? Yang I'm Syahmi acting on behalf of my client. Is it that considered as opening speech?
Not yet. Not yet.
Not yet.
That is only introducing parties.
Okay.
Belum we opening speech lambat lagi. So opening speech nanti we will discuss opening speech when we discuss the conduct of the trial. This is only introduction saja. You introduce the party, address the judge, address the opponent. I mean introduce the opponent, introduce yourself. That's it. As an introduction. Nanti opening speech when you want to start your trial, before you call witness, then opening speech. I will definitely discuss with you on that in next classes. Okay. So any other questions? Kalau tak ada, okay, I will normally I use Google Classroom untuk assign case ke or assignments. So for this normally in my class my first assignment is before that you guys will be divided into firms or not? Akan ada firm.
Yes, we already have our own firm.
So now you have your own firm lah. So
Yes.
I mean, it applies to all subjects, is it?
Yes.
Okay, good. So I will invite you guys into my Google Classroom. I will send invitation link in the WhatsApp group. So you masuklah kat situ. Okay, my first assignment, not really assignment lah. I just want to get to know you. You all first, everybody mesti buat CV. You know CV? Curriculum vitae, whatever it is. CV or resume. Okay, saya akan assign in Google Classroom. Kat mana-mana pun saya akan buat macam ni. So you buat CV personally and then you send into Google Classroom. I will give a deadline before the next class. CV senang saja. You Google, ada sample, you letak your name, you letak your particulars and then you letak your gambar kat situ macam you nak, as if you want to apply for a job. Okay, you can later on use this CV to apply for your chambering pun. So might as well, okay, dengan Sir Yusuf Rizal, kita orang kena buat CV. So you prepare awal-awal. This is your final semester, right?
Yes.
Second last semester.
Second.
Oh, second last semester. Okay, tak kisah. So prepare your CV, number 1. Banyak ni, sebab tak ada tutorial kan? So number two, each firm need to prepare a firm's profile. Okay, firm profile ni simply this. You letak all the partners and then the sikit biodata, a summary of biodata, and then you kena letak what are your area of practice. What is your expertise? Apa you punya you punya your area of expertise dan your focus. Are you doing criminal litigation? Are you doing civil litigation? Okay. Nanti ada orang akan tanya, kita orang tak ada experience lagi, macam mana nak buat ni? Memanglah, you should imagine yourself sekarang ni, you have opened a real firm. So you letak lah, tak betul pun tak apa. Okay, you letak. Okay, maybe you have a logo sikit, you punya profile tu mungkin nak letak gambar macam mana ke, whatever lah. Okay, tapi contoh banyak, you just Google saja firm profile. So you letak area of expertise dan juga ikut creativity you, whatever content that you want to represent your firm. Okay, I don't mind if the information is not really correct. Mungkin you cakap you dah buat banyak case on accident case ke, whatever. Use your creativity, but then I need it to represent your firm. So that seolah-olah I'm potential employee. So I look at your CV, look at your firm, and then I will, offer you a job, for example. Okay, so that is your first assignment. Deadline is before next class. You submit in Google Classroom. For CV, everyone have to submit, each one of you. For firms, seorang saja from that firm lah, wakil, the representative of that firm submit through Google Classroom. Okay, I will give further instruction in Google Classroom lah. I will invite you first. Sekejap lagi saya terus create the link, invitation link, and then you all semua masuk kat situ. You all pernah guna Google Classroom kan? Tak pernah. Tak apalah. Sebab saya I'm not really familiar with this Microsoft Meet lah. So tak apa. Untuk kelas kita boleh guna this one. The reason I want to use this Microsoft Teams sebab Google Meet I tried dekat kelas saya kat URA tu very unstable. Otherwise saya dah guna Google Meet. So that's why saya guna Microsoft Teams, but Google Classroom is very interactive in terms of submission of assignment. Okay guys, that is all. Itu saja. Kalau tak ada apa-apa, I'll see you next Thursday. 8 sampai 10 Khamis minggu hadapan. Kecuali kalau ada perubahan saya akan bagi tahu through Syami lah ataupun in WhatsApp group or in Google Classroom. Okey,
Okey, sir.
itu saja. Assalamualaikum warahmatullahi
Waalaikumsalam.
wabarakatuh.
Thank you, sir.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, sir.
Thank you, sir.
Thank you,
Okay.
sir.
Thank you, sir.
Thank you, sir.
Thank you, Doctor.
Thank you, sir.
Welcome. Syami nanti bagi attendance.
Thank you, sir.